Dowry is a serious crime, but the Anti-Dowry Act has been proving to be a double-edged sword, and the Supreme Court wants its misuse blunted. It has come down hard on the abuse of Section 498A of the Indian Penal Code, saying disgruntled wives should stop using it as a weapon to harass their husbands and their families. The police has now been directed to weigh the case before making arrests. Arrest will need to be justified subject to judicial appraisal. The court has said that attitude to arrest first and then proceed with the rest is despicable. State governments have been directed to ensure that police forces fall in line with the order. The order says the police officer shall forward the checklist duly filed and furnish the reasons and materials which necessitated the arrest, while forwarding producing the accused before the magistrate for further detention. The fact that Section 498A is a cognizable and non-bailable offence has lent it a dubious place of pride amongst the provisions that are used as weapons rather than shield by disgruntled wives.
एक पर्सन का सबसे वैल्यूएबल राइट है कि अगर वो एक बार अरेस्ट हो जाता है, ये हमेशा के लिए उसके लिए एक स्कार, एक स्टिग्मा हो जाता है। तो उससे बचाने के लिए, और ये फंडामेंटल राइट है आर्टिकल 22 में, कि आप ऐसे एकदम से किसी की लिबर्टी को नहीं ले सकते हैं, उसको कोर्ट ने प्रोटेक्ट किया है। और जो मिसयूज हो रहा है डॉरी लॉज का पर्टिकुलरली, उससे एक लोगों को निजात दिलाई।
Legal minds have welcomed Supreme Court's order.
The law on arrest has been laid down by the Supreme Court that during investigation arrest should be made only in 3 situations. If the person is likely to run away and not face the investigation, or if he is likely to tamper with evidence, or if he is likely to repeat these kind of offences, if the offence is very serious and he is likely to repeat those offences.
Political outfits, however, are divided.
कानून बहुत सोच समझने के बाद और हकीकत को देखने के बाद बना, क्योंकि तब तक कोई भी प्रोटेक्शन नहीं था किसी लड़की की। तो सुप्रीम कोर्ट उस प्रोटेक्शन को समाप्त करना चाहती।
मिसयूज तो होता था और ठीक है, माने हम समझते हैं कि कोई बेजा बात नहीं कही है सुप्रीम कोर्ट ने।
Women activists are dismayed that this will hurt the cause of those who have genuinely been harassed for dowry.
क्राइम है औरतों के विरोध में, जो डोमेस्टिक वायलेंस है, उसी कानून को आप कमजोर कर लेंगे तो फिर आपने अरेस्ट की धारा ही क्यों रखी है? आपको उस धारा को ही हटा देनी चाहिए। आप किसी को मत अरेस्ट कीजिए, और ये 498A में ही क्यों?
The National Crime Record Bureau's data for 2012 shows almost 2 lakh people were arrested for violating the Anti-Dowry Act. Nearly 5,000, that is 1/4 of those arrested, were mothers and sisters of husbands. Dowry crimes account for 4.5% of all crimes committed under IPC, third highest among all crimes. And while 93.6% of dowry cases are charge-sheeted, conviction rate is just 15%. The judgment has once again racked up the issue of misuse of law. The question now is, how will this impact the functioning of the police at the ground level, not only in dowry cases, but in all crimes which prescribe a punishment of 7 years or less if found guilty. DD News.